Section 47, subsection 2 of the Electoral Act 2022 makes it mandatory that to vote, the presiding officer shall use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. So the use of the beavers is a mandatory provision of the law and is not an option of charity. The Commission does not have a discretion on whether to use the beavers or not. The law says that we shall and must use the beavers, and this Commission is committed to using the beavers because we spend so much time, we spend so much energy, and we spend resources in putting together the beavers. The beavers was developed by the Commission's in-house engineers as a way of making sure that identity theft is minimized as much as possible at our polling units. So we cannot spend time, resources to develop the beavers and then throw it away and say we won't use it again. It doesn't make sense. So the beavers has come to stay, and we are going to continue to use the beavers in all our elections. The Commission will also transmit polling unit level results in real time. The transmission of polling unit level results is also a mandatory provision of the law, as Section 64, subsection 4 of the Electoral Act has made it mandatory. We canvass for the inclusion of the beavers and the electronic transmission of results in the Electoral Act. We therefore have a responsibility to keep faith with our own innovations aimed at the conduct of transparent elections driven and propelled by technology.
There is nothing like electronic transmission, because transmission is when you vote and it goes to the server. What we have passed, and I can recollect this vividly because I read that act when it was a bill several times, is to transfer. After all the paperwork that we normally do are done, the agents and everybody there, security, everybody will have the papers. INEC will snap or scan or snap the result sheet and transmit or transfer or whatever it is. That whether it is transmit or transfer is that thing that is captured with beavers, the results. And for me, my understanding is if any result that was captured and sent differs from something gotten somewhere, that one is illegal. And only the courts, it's not us here that can do. So we urge INEC to follow the Electoral Act. And for me, my understanding is if any result that was captured and sent differs from something gotten somewhere, that one is illegal. And only the courts, it's not us here that can do. So we urge INEC to follow the Electoral Act and other laws.
Welcome to my channel, where we discuss everything and all things politics, especially about the 2023 presidential election in Nigeria that was held on February 25 and the result announced on March 1st, 2023. In this video, which you have watched, two videos that will help to explain the subject of our discussion today, or in this video. We are going to look at the final written address by the Independent National Electoral Commission. They have submitted their final written submission in the ongoing Presidential Election Petition Tribunal. And in that final written submission, they claim that Peter Obi failed to show that he scored majority votes. That's what they told the courts in their final written address. The Independent National Electoral Commission, they argued that Labour Party's presidential candidate, Peter Obi, failed to show how he scored the majority of lawful votes during the February 25 presidential election. And you know that in the vote allocation that was done by this same INEC, they put Peter Obi in the third position. And you know, Peter Obi filed the petition to challenge the outcome of the election, alleging that there were fraud and irregularities in the election. And Obi call on the courts, or urge the courts to nullify President Bola Ahmed Tinubu's victory in the poll. He also called on the courts to either declare him the winner of the election or order a fresh poll. And Peter Obi and Labour Party, they allege that Tinubu and Vice President Kashim Shettima were not qualified to vie for Nigeria's presidency. And they allege that Tinubu was convicted of drugs-related crimes and forfeited $460,000 to the United States government. They also accuse Shettima of double nomination by their party, the All Progressive Congress. And Obi contended that Tinubu was not duly elected by the majority of the lawful votes cast at the election. Obi called 13 witnesses to back his claim. And the 5-member panel of the court, led by Haruna Samani, had ordered parties to the case to exchange their final addresses at the end of the trial. In his final written address, INEC, through his lead lawyer, Abubakar Mahmood, senior advocate of Nigeria, said that Obi's petition lacks merits. Responding to the allegation of Shettima's double nomination, Mr. Mahmood said the APC had, in a letter dated 6 July 2022, received on 13 July 2023 by INEC, withdrawn his candidacy for Borno Central Senatorial District to clear the way for his nomination as Mr. Tinubu's running mate. He clarified that Mr. Shettima's voluntary withdrawal preceded his nomination as Tinubu's vice presidential pick. Also addressing the issue of Tinubu's alleged trafficking of narcotic drugs in the US, Mr. Mahmood said there was no criminal charge, sentence, or conviction to support the allegation of criminal conviction or forfeiture. We are going to address these issues. They are claiming that, referencing a letter from the US government tendered during the defense. And he said that the alleged order of forfeiture, being that of a foreign court, is not registered in Nigeria to be enforceable. The forfeiture order made by Judge John Nordberg of a United States District Court on 4th October 1993 is in fact over 20 years since the alleged order was made. Mr. Mahmood said, referencing the Tinubu's defense on that matter, we're going to address these issues to show that INEC goofed. On the issue of INEC's failure to upload polling unit results of the presidential election to its result view portal in real time on February 25, Mr. Mahmood said that electoral officers could not transmit the image of the results to the IRA portal due to technical glitch that occurred on the e-transmission application by Amazon Web Services. This technical glitch was eventually resolved, but we know that that was not true. There was no glitches at all. It was deliberate glitch that was created by INEC people. There was no glitch. The Amazon Web Services witness that was brought by Peter Obi was able to show that there were no glitches before, during, and after the presidential election. Now, INEC sole witness had during his testimony tendered the Amazon Cloud Trail in support of the claim that there was a technical glitch on the Commission's portal during the presidential polling. That was a lie. The INEC Deputy Director of ICT was not able to convince anyone there were glitches. He was not able to convince that. Because if there were glitches, they didn't report it to Amazon, because they ought to report it to Amazon, because they paid Amazon to protect their website or their server. If there was a glitch, Amazon needs to be informed, and Amazon used to make a refund to the federal government, because it means that Amazon failed its responsibility of protecting the server of INEC. But there were no glitches, so there was no need for them to report to Amazon. So it was a lie in this their final submission that there were glitches. It's not true. Mr. Mahmood said the evidence of INEC's sole witness, Lawrence Bayode, an assistant director at the Commission's ICT department, was uncontroverted. It's a lie. It wasn't uncontroverted. Mr. Bayode, during his testimony, stated that he was one of the persons who designed the INEC e-transmission system and helped resolve the technical glitches that occur on election day. If he helped in resolving it, why didn't they transmit the results? Why didn't they transmit the results? Why is it that throughout the whole day, throughout the whole night? So when did they resolve it? After the whole election had finished, or what? Said they resolve it. So they resolve. So why didn't they upload results into the? Why didn't they release the code for presiding officers to be able to transmit the results, the presidential election results? Because the presiding officers were able to transmit the senatorial and House of Representatives results, but they couldn't transmit the presidential. So it's a lie from the pit of hell on the part of INEC to lie so blatantly in their final written address. He claimed that petitioners neither pleaded nor demonstrated at trial any unlawful votes of the second respondent to be discounted from the computed scores of the parties, and did not present any lawful vote to be added to their own. This clearly showed failure to lead any evidence to support them. It's not true. Peter Obi, this claim that Peter Obi did not show proof how he got majority of the vote, is not true. Peter Obi's witness, like the professor of mathematics, like him, he was able to prove that there were 18,088 blood result sheets that they used in announcing Tinubu as the winner of the election. Now that 18,088 blood result sheets, nothing was written on it. It represented about 2.5 million votes that were illegally allocated to Aswad Bola Ahmed Tinubu, according to that witness. Now, if you subtract that 2.5 million votes from Tinubu's 8.7 million votes, Tinubu's number will come down to 6.2 million votes. And by the time they remove Rivers State and Benue State from among the states that Tinubu won, Tinubu's number of states where he won will come down to 10 states. And Peter Obi's number will get to 13 states plus Federal Capital Territory, Abuja. That is enough to show that as Tinubu's numbers are dropping because of the removal of the padded votes and the illegal and the states added to him which he didn't win, like Benue and Rivers, his numbers will come down. And this they presented in court. So it's for INEC now say that Peter Obi didn't show any proof that he has the majority. These are the processes of getting the majority. When they remove the illegal votes that INEC allegedly padded for Tinubu, his numbers will come down and Peter Obi's numbers will go up. So it is not true in their presentation that Peter Obi was not able to prove that he has the majority of the votes. I have just explained the process of Peter Obi having majority of the vote, and this is the process I keep telling people, that Peter Obi will move from number 3 to number 1 position. Because in reality, Peter Obi was the number 1 candidate in that election. But for the manipulations that was done, Peter Obi has the highest number of votes cast in terms of winning, majority of the vote cast. He has it. But for the election rigging. And the essence of the court is for the court to right the wrong that was done to Peter Obi. So INEC is wrong there to say that Peter Obi was not able to show that he has majority of the votes. Now, in the issue of 25% votes in the FCT, he said that Mr. Obi's contention that Tinubu ought not to be declared the winner of the election for failing to score 25% of the lawful votes cast in the Federal Capital Territory, Abuja, in the presidential election. He said that the commission said that this clearly has nothing to do with lawful votes or unlawful votes. It noted that the issue is clearly one of interpretation of the relevant constitutional provisions. Here, they were not able to say that it was not true. They only said that it's clearly one of interpretation of the relevant constitutional provision. So they didn't go any further here. But the fact of the matter remains that based on section 134 subsection 2b, they ought not to have declared Tinubu the winner of the election, having not gotten 25% of the vote cast in the Federal Capital Territory, Abuja. Then the lawyer of INEC went on to say that there was no mandatory obligation prescribed by the Electoral Act for INEC to electronically transmit and collect the result of the election or to fully upload same on IRIF before collection of results. You know, that was why I played the video of Festus Okoye, where Festus Okoye made it clear that it is compulsory. The electronic transmission of the result is compulsory. The accreditation, electronic accreditation using beavers was compulsory. And we are going to look into some of the sections that he cited when he was speaking earlier on, when we started before we started this conversation. And you saw clearly and heard clearly what the former Senate President said about the issue of the role of the transmission of the results to the INEC IRIF. You say where there is a dispute, the one that is being debated, the one that people are carrying, the hard copy is fake. It's not true. The correct one is the one on the beavers, on the INEC IRIF. That's what he said. That's the one you use. And that was the one that will finish Tinubu, because the 2.5 million votes that was allocated to him through the blood result sheets of about 18,088, it shows that that result has to be cancelled, because they were not true, they were fake. Because there's a dispute about what is the correct result. You cannot compare it, because what was in the IRIF that would have been used to compare the result that Labour Party is holding and the result that APC is holding and the result that PDP is holding is blood. So there is nothing to use to compare the results. Therefore, it is invalid. And that is why that 2.5 million votes must be subtracted or should be subtracted from Tinubu's number of votes. That's the way it is. You had it clearly by Amelawa. He said when there is a dispute between the from EC8A, which every polling agent, political parties, security agents, and the polling units, they have those. If there is a dispute over the result, the one that is supposed to be the guy, the anchor, that will clear any doubt is the one that is on the INEC server. Now the one that is in the INEC server is blurred. So what do you compare the result that INEC is bandying about, they using announcing Tinubu, and the one that Labour Party is holding, and the one that PDP is holding? It means it has been invalidated. Can't stand. Now, these are some of the issues that came up. So we're now going to look at, to show in detail that INEC was not able to convince anybody that Peter Obi didn't win this election. They were not able to dismantle Peter Obi's position at all, from what they are saying here, and from the video I put earlier on for you, so that you know how these things, the foundation of it. Okay? You can see that before I go for that, let us look at this section 134(2) of the Constitution that talks about the status of the FCT getting 25%, because INEC itself is claiming that it doesn't matter, that Abuja is considered the 37th state of the Federal Republic of Nigeria. It's not true. Section 134, subsection 2B was very clear when they talk about that for anyone to be declared the winner of the presidential election, the person must have majority of the vote cast. The person must have 25% in 2/3 of the 36 states of the federation and the FCT. So the idea that the FCT is 37 states is not true. I hope the court would, the justices will take note of that. INEC goofed by saying that FCT is considered as 37 states. It is not true. Okay? That's what they are claiming in their final written statement. And they were saying that Labour Party's petition should be dismissed in the case of the FCT too. Okay? But let us look at what the Constitution is saying in section 137. Section 137 of the Constitution itemizes the conditionality that somebody could be disqualified from becoming president of Nigeria. Okay? And that section is where you will find out the reason why Tinubu should be disqualified based on that section. Look at what this section is saying. Section 137. A person shall not be qualified for election to the office of the president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or a fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. So this is the section that will disqualify Tinubu, because By forfeiting $460,000, it means that he committed a crime. He committed an act of dishonesty. That is enough. And what is forfeiture? You can't forfeit unless you have committed a crime. So INEC was wrong in saying that what Tinubu did was not a crime. That it was not a crime, it was a civil matter. It's not true. Cocaine, narcotic trafficking can never be a civil matter. It's not a civil matter. Because the forfeiture is what nailed Tinubu there. By forfeiting, it means he committed a crime. He may not have been sentenced to prison, but that forfeiture is an admittance of crime. It's an evidence of commission of crime. Now, in 2014, the Supreme Court defined forfeiture as punishment for an offense under Nigerian criminal statutes. So that is how the Supreme Court defined it, as punishment for an offense. So Tinubu's forfeiture of $460,000 was as a result of commission of an offense. Now this is how the Supreme Court defined it going further. It said the word forfeiture means that the divestiture of property without compensation, the loss of a right, privilege, or property because of a crime, breach of obligation, or neglect of duty. The court ruled on January 17, 2014 in Mohammed Abacha and the Federal Republic of Nigeria. A person who has forfeited property on the basis of a crime cannot be entitled to indemnity. So Tinubu committed a crime by the forfeiture of $460,000. So he remained disqualified. He ought to be disqualified based on that. Forfeiture is a form of punishment. So if you didn't commit a crime, you won't suffer any punishment. But when you forfeit, it means that you are being punished for the act of criminality that you committed. So it's a crime. Forfeiture is a form of punishment. There is no indemnity in our criminal procedure. The Supreme Court further stated in 2014 in a majority decision delivered by Chief Justice Olukayode Arewola. So that's the fact. So INEC cannot claim that this is not the fact of the matter. So for them to say that the court should dismiss Peter Obi's petition when this weighty allegation is on Tinubu, it means that they don't know what they are doing. They think that they can deceive the justices or Nigerians who are also who have access to this same constitution. Now, INEC claimed that he saw witness during the testimony tendered Amazon Trail in support of the claim that there was a technical glitch. That's not true. That's not true. Lawrence Bayode was not able to convince anybody. He was not able to convince anybody. In fact, he himself admitted there were no glitches when he was interrogated by the lawyers of Peter Obi. So there were no glitches. So for INEC in their final written address to claim that the ICT deputy director was able to prove there were glitches, it's not true. It's not true. And in the case of the 25% vote in the FCT, it is a settled matter that you must get 25% in FCT. This matter has been settled in 2008 was the last time it was settled between Muhammadu Buhari and Umaru Musa Yar'Adua. And the court ruled that 25% in FCT is compulsory because it is conjunctive. That's section 134, subsection 2B, that for anyone to be declared the winner of the election, they must get 25% in 2/3 of the 36 states of the Federation and the Federal Capital Territory, Abuja. It is not optional, and it's a must. If you don't get it, you can't be president. So INEC erred in declaring him winner, in declaring Tinubu winner when he didn't get that 25%. So it is something that we believe that the Supreme Court cannot change its mind from what that particular and is now. Because in 2008, the Supreme Court ruled that it's conjunctive. So they can't change it now. They can't change it. They can't change their mind now. So it's obvious that INEC could not be able to defend why they declared Tinubu winner. And then we have to look at the issue of transmission of results, which we started some of the videos at the beginning of this conversation. And you will see where Festus Okoye cited section 47, subsection 2 of the Electoral Act 2022, which makes it mandatory that to vote, the presiding officer shall use the smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Okay? So electronic accreditation was made compulsory. So the use of beavers is a mandatory provision of the law. So the idea that it is optional is not true. The idea that it is optional by INEC is not true. It is from the mouth of INEC official, Festus Okoye, and he was citing the Electoral Act in his submission. He says, so the use of beavers is a mandatory provision of the law and is not an option of charity, he said. He said the Commission does not have a discretion on whether to use the beavers or not. The law said that we shall and must use the beavers. And he said that the Commission is committed to using the beavers because they have spent so much time, so much money, so much energy and resources in putting together the beavers. And the Electoral Act says it is it's not optional. Because anywhere you see in the law, they say shall, it means it's a must. It is not optional. And he said in the video that you watched that the beavers was developed by in-house engineers, which means it was to show you how serious INEC took this matter. How serious they took this matter. They develop it in-house. So how can they develop all these things on the election? INEC is not telling us that it was optional. Okay? He said it was a way of making sure that identity theft is minimized as much as possible at the polling units. And he said that they cannot spend time, resources to develop the beavers and then throw it away and say that they won't use it again. He said it doesn't make sense. But now it's trying to make sense for them to come and deny it in the court. That is compulsory. He now said that you had Okoye, you can watch it back again. Okoye was saying, he said, so the beavers has come to stay, and we are going to continue to use the beavers in all our elections. And he said that the commission will also transmit polling unit level results in real time. He said the transmission of polling unit results is also a mandatory provision of the law. Now INEC is trying to tell us that it's not compulsory they transmit the result live in real time, that now you can use the manual collection of results. It is not true. He said that the transmission of polling unit results is also a mandatory provision of the law. That's the electronic transmission. At section 64, subsection 4 of the Electoral Act, he said it has made it mandatory. And now people are coming, and INEC is trying in that last submission, telling us that it was optional, that it's not compulsory. They think we are fools in this country. No, we are not fools. So you can see that Peter Obi has a good ground to challenge the results of Aswan Bola Tinubu. And INEC could not be able, from their last written address, they could not be able to convince anyone that what Peter Obi presented and all this evidence against them is not true. So I think we have succeeded in convincing you that INEC was wrong in claiming that Peter Obi's petition should be discarded. No, it cannot be discarded because it is weighty. It has been able to prove his case, as far as I'm concerned, based on what INEC promised to deliver and based on the Electoral Act, which you saw Festus Okoye talked about it. So anything that INEC did that was outside the Electoral Act, it means that they have failed in that respect. That election had to be cancelled or something done to it. It cannot stand. And you also saw former Senate President telling you that when there is a dispute between the results held by different political parties on the election, that the most reliable solution to the dispute is to go and check what is contained in the IRIF. Now, what is contained in the IRIF were blood results, 18,088 blood results, consisting of 2.5 million votes. And those votes that was allocated to Tinubu, it has to be taken away from him. And when they are taken away from him, I don't see how Tinubu will have majority of the vote cast in the election. Thank you for watching this video. And if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel, hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. God bless you and yours.